Good morning, everyone. Good morning, everyone. How are you doing? Right. With all the introductions that have been done, we are ready to proceed. We would only, for now, ask that we have the verbal introductions as to who is appearing on behalf of who, and thereafter we will then make the timekeeper to start running so that we can hear arguments. Is there anything that we need to consider or that makes this matter not ready to be heard? You need to address us on that. Unless if you are all ready to shoot and present your arguments, we will immediately proceed once you have individually introduced yourselves. I'll then start with the applicants. I recall the applicants were to be on our right and the respondents were to be on our left. Anything before you introduce yourself that you feel needs to be addressed before the hearing proceeds? Applicants, before you introduce yourself, anything that you feel needs to be addressed before we proceed? Yes. Okay, we will get to answer that before we proceed. Anything?
Applicant. So they said the applicants should sit on the right hand side and the respondents on the left.
Okay. Oh. Maybe you missed it or you misunderstood it.
We missed it. We might have missed it.
Okay, let me clarify it. When they say on our right, they mean the bench's right, which is the applicant. And when they say on our left, they mean the bench's left, which is this side.
Understood.
Without any waste of time, I'm just going to give one of my colleagues, maybe they want to clarify any other issue with them. Immediately when they are done, we then immediately start with individual introductions of the applicants, and we get to the individual introductions of the respondents.
Thank you. Good morning once again, guys. I don't have anything to clarify on my side. I just want to wish you all the best. Take your time in responding to us, and yeah, just be clear and eloquent. Okay, all the best. I'll hand over to my brother over here.
Thank you. I don't have anything to say. We are ready for you.
Remember, we indicated that the time will start kicking immediately after your introductions, with the applicant presenting its case and the respondents come thereafter. We are going to answer your question that you raised, but for the record, let's all have your names. You can just introduce yourself. And I'm not so sure as to the question of using of a mic. We will just get an indication as to whether is it okay if we proceed with the hearings without using same, or we should always use same. As and when you are introducing yourself, let's find from one of the technical guys sitting around here as to whether it's necessary for us to use the mic or not. But in the meantime, you will proceed to introduce yourself so that we can write your full names onto the record. Applicant, shoot. Introductions.
As witnesses in the court, justices, my name is Jeremiah, and I'm appearing in my capacity as counsel for the applicant.
Jeremiah. Thank you.
May it please the court, my name is I am counsel appearing on behalf of the applicants. May it please the court, the justices, my name is Matala, counsel for the applicants.
Just on a lighter note, you know this so-called constitutional court, others call it Concord. We normally get senior counsels appearing, and I may have gone through your argument and your filed documents. I thought as and when you're introducing yourselves, you will not forget the status behind. So I shall take it that there is no senior counsel appearing then. That was just on a lighter note. The respondents, can we get your individual names?
As it pleases the court, I am Amelia Kekana. I confirm my appearance on behalf of the respondents.
As it pleases the court, my name is Kokejo Mukwena, confirming my appearance on behalf of the respondents.
As it pleases the court, my name is Bopedi Riabetu. I'm confirming my appearance on behalf of the respondents.
Can you just repeat your name again, madam?
Bopedi Riabetu.
Bopedi?
Riabetu.
So you also forgot the respondents to indicate who is a senior counsel on your part. That's fine. All right. As I was waiting with my learned judges here, I haven't received an indication as to whether we'll be okay without the mic or not. Okay. We need the mic. Okay. Then maybe it means the introductions, which were not most important, have not been recorded properly. But with that said, time is not on our side. The question that has been asked by Advocate Jeremiah Kekana relates to whether this court should begin to hear the arguments on the admission of an amicus curiae, which is item 7, that is appearing elsewhere on the heads. It is common that ours is to hear your views and then we decide. So I'm going to do what the natural process allows us to do, which is there has been a preliminary issue raised by the applicant in terms of this court giving a direction how we should proceed. So I'm going to ask from the respondents what is their view or their response towards a preliminary suggestion that we should deal with issue 7. Is the respondent ready to address this court on that issue? Whether we should first consider the admission of an amicus curiae or not? May I hear from the respondents? Advocate Kekana stood up and raised the question as to whether is it not prudent or is it not better for this court to deal with the issue of admission of an amicus curiae. I just want to hear your views on that raised aspect.
As the court pleases, me and my we as the counsels, we prepared in considering the issues how they were numbered. So we are comfortable with how we prepared with from issue number 1 to 7. We can't start from how from issue number 7 to going up. So we don't feel comfortable with the preliminary requests.
Okay. Any further addition from the respondent so that we can quickly dispose of this issue? All right. Let me just take a moment to confer with the panel members as to the request that has been made. Okay, I have just had a quick discussion with my two brother and a sister. We are of the view that says, if these proceedings were to continue right away without the determination of whether the other request of being a party or not is accepted, we would be sort of jumping the gun. So without any waste of time, we are going to proceed to hear arguments on the admission of the amicus curiae. It is an important preliminary issue which must indeed be finalized before we get to the hearing, because their admission or lack thereof will then determine whether they are going to participate in these proceedings or not. I may note that the respondent was not comfortable with the view that we need to start with number 7, but unfortunately, we have just made that decision now that, yes, indeed, we agree with the applicants. We will immediately proceed to hear arguments. What that does on the respondents is that once they have argued, you'll immediately respond to that, and maybe we will have a short adjournment for us to decide on the admission of the amicus curiae. So the respondents, you simply have to adjust. Your number 7 will be argued number 1. With that said, I am not sure if we need to allocate time to this argument, because it is not necessarily part and parcel of the planned 30 minutes that we ought to hear. Let's say for now, until a further directive is given, we will allow the applicant to present its case on this amicus curiae issue for 5 minutes, and the respondent will also respond on the issue of amicus curiae for 5 minutes. With that said, are we ready to start? Applicant, Advocate Kekana, your 5 minutes starts right away. Maybe by the way of proper process, you would then have recalled that it is indeed the amicus himself who ought to be presenting the question of whether, why he or she should be admitted. But for the purposes of this process, you'll both have to argue that, which is not necessarily related to the merits of your case. Your 5 minutes starts now. Are you going to argue the matter alone, or your colleagues will also be supplementing?
Alone.
Alone. Thank you. On the respondents, prepare yourself, somebody to argue on the matter for the next 5 minutes after Advocate Kekana is done. Just on the question of amicus curiae. Thank you.
As it pleases the court, your justices, it is imperative that we admit the amicus curiae in these proceedings simply because of 2 things. The amicus curiae, your justices, specialize in research and advocacy for customary law and customary practices. Secondly, your justices, the amicus curiae is in possession of evidence, documentary evidence to be precise, which will be very vital with regards to the proceedings that have brought us before this court here today, your justices. So that is the basis of which the amicus curiae should be admitted in these proceedings. Your justices, as the applicants, we have submitted an application in terms of Rule 10.
Counsel, I heard you saying that the amicus has important documents.
Correct.
With regard to the case. Where are those documents coming from? Because I understand there's the applicants, you are Amicus, and you are saying that there's important documents. These documents part of the applicants, or where are they coming from? Please clarify to the court.
So your question, Your Justice, is where are the documents?
Yes, you indicated that the Amicus has got important documents. So I am saying that where are these documents coming from, and what do they entail?
Your Justices, these documents that I'm referring to is documentary evidence. It is videos that were taken during the illegal evictions that were happening while the community of the Shiqane Msenge were being evicted from their homes. What I'm referring to you right now is actually on the facts, Your Justices. The facts do state that there is documentary evidence of which the Amicus Curiae has at their disposal.
Can you please direct me to the particular paragraph?
Okay. Beg the court's indulgence. Can I just consult my notes, please? Your Justices, the paragraph that I'm referring to is paragraph 2.14, which starts on page 6 and ends on page 7 of the facts.
Proceed to wrap up, Advocate Kekana. You were just about to address us on Rule 10. Your 5 minutes is just about to end.
Your Justices, as the applicants, we have submitted an application in terms of Rule 10 before the court to have Save the Culture admitted as an amicus curiae. It must be noted that the amicus is merely a friend of the court and not acting as an intervening party to the proceedings in terms of Rule 8. In Hoffman versus South African Airways, the Constitutional Court places the following distinction, open quote. An amicus curiae assists the courts by furnishing information or arguments regarding questions of law or fact. The amicus is not a party to litigation but believes that the court's decision may affect its interests. The amicus differs from an intervening party who has a direct interest in the matter, or rather in the outcome of the litigation, and is therefore permitted to participate as a party to the matter. An amicus joins proceedings, as its name suggests, as a friend of the court. Your Justices.
Your 5 minutes is up, but we will get you an extra minute.
If it pleases the court, Your
Yes.
Justice, may I please have 2 minutes?
It's only a minute, Advocate Kekana.
Noted. Thank you, Your Justice. Your Justice, just to deal briefly with regards to the issue of evidence. It is a general rule that in our law, evidence cannot be adduced before a court of appeal, and that the appeal court ought to deal with the merits of the case as they appear on the record before it. Now, Your Justices, Rule 31 of the Constitutional Court rules states that any party to the proceedings before the court and an amicus curiae properly admitted by the court in the proceedings shall be entitled, in documents lodged with the register in terms of these rules, to canvass factual material that is relevant to the determination of the issues before the court that does not specifically appear on the record. Your Justices, I just also want to make reference with regards to Section 173 of the Constitution, which gives the superior courts an inherent power to regulate as to how they want the proceedings to unfold. I just made reference to the fact that in a court of appeal, normally it is a general rule that new evidence is not to be adduced before a court of appeal. However, the court, with regards to Section 173 of the Constitution, can invoke to have the evidence be admitted before the Honorable Court, Your Justices.
Thank you. It's fine, we have heard you, Advocate Kekana. The time for the respondents to respond to the admission of an amicus curiae starts now. Just a second, Advocate Bopedi. We just need to get some clarity on the presentation by the applicant. My brother wants to probe a little bit, so just bear with us. Your time is not affected.
Thank you so much, Counsel. Advocate Kekan, I heard you saying that the amicus is there to assist the court, and you quoted the case of Hoffman, which this court has presided over some times ago. But I have an issue, because as an amicus, you are having evidence which shows the recordings of harassment, intimidation and forced removals and so on. But you are saying that you are only here to assist the court. You are not taking sides. Because my understanding is the position of the applicants. I understand that you are part of the applicants, but you are amicus, and you want to convince the court to admit the amicus, but you are having evidence which is assisting the applicants. So, but you just said to us that amicus is there to only assist the court, not to take sides with the defendants or the applicants. So please clarify to me, why are you as amicus having evidence which seems to me to be assisting the appellants or the applicants?
Justices, big indulgence to just give me a moment to find the relevant law which will seek to address your question, Your Justice. Okay. Your Justices, it is actually in the case that I quoted, the Hoffman case, whereby the court specifically states that an amicus can take sides or can choose sides in the proceedings.
So are you changing what you said initially?
No, Your Justice, I am not changing what I'm saying. The role of the amicus is to play a pivotal role in the proceedings, to assist the court as a friend of the court. However, in the case of in the Hoffman case, Your Justices, the court specifically said that an amicus is allowed to pick a side unless it is directed otherwise by the court.
Okay, thank you. We would deal with your argument, obviously, with a view of determining the admission or not. Advocate Bopedi, is it correct to say to you, Advocate Bopedi, or maybe you are not an advocate, I'm not sure.
Soon to be.
Say that again? You'll soon be. Okay then. All right.
Of curiae, with the admission of the amicus curiae to this court. We argue that save the culture is not a matter of interest to this court. It will play no role in assisting the court to arrive at a just and equitable decision. And amicus, the applicant stated that an amicus curiae is permitted by factual material that is relevant to the determination of the issues before the court. The material submitted under consists of statistical from sources which are generally accepted and reliable. We argue that the information from the sources, the applicant's argument in admission of an amicus curiae rely on the evidence the NGO is going to be the NGO is claiming to be in possession of, which they mentioned as the documentary evidence and the video recordings. We argue that the evidence intended does not meet the requirements of the section that the applicants have quoted, Rule 31 of the amicus curiae. The role of the amicus curiae is to assist and advise the court in promoting the interest of an admission of justice and not bring evidence to this court. This brings down the fact that the NGO is unqualified to assist the court, looking at the intended evidence brought, the intended evidence they're bringing to this court. Furthermore, we argue that admitting an unregistered organization may unduly extend the proceedings without substantial benefit. While recognizing the importance of preserving customary law and traditions, the respondent contend that specific circumstances of these cases are adequately addressed by the parties directly involved. Save the Culture's lack of registration raises questions about the credibility and ability to provide impartial and well-informed perspectives. We conclude that to request the court to exercise discretion in admitting an amicus curiae. I may not be of further assistance.
Thank you. The time was well managed. I must thank the counsel on behalf of the respondent. Anything further you want to reply upon what they have presented before?
I'm saying this because just to give you the picture of where we are going with the decision to be made. You have made presentations and arguments regarding the evidence you refer to the Hoffman. They have raised 2 or 3 issues which you have not addressed and which are critical for you to respond. The lack of registration of the institution, the fact that what they are going to allege is not going to assist the court. And with those said, you need to respond so that we then know what is your version given what they have presented. And if my memory recollects well, these are some of the issues that we have seen during the result of your heads of argument of the amicus curiae. However, you have the last bite of the cherry to respond to these issues. The floor is yours.
As it pleases the court, your justices, with regards to the registration of the NGO, them being registered or not registered is I find that argument to lack substance, your justices, because of it lacks substance, your justices, because of the Concord rules specifically says that any interested party, and I want to emphasize this, it says any interested party can write to the court to be admitted as a friend of the court. Now, your justices, the term any interested...
I'm not a judge. judge that normally gets when counsel making his argument, but one is tempted to do so for the sake of understanding and for the sake of you persuading us. If this issue is of no relevance, a hypothetical situation that I may pose to you, does that mean that any person who has an interest, whether a non-South African, whether a Canadian, whether an Australian, can approach a South African court simply because of the knowledge of culture or the evidence that he may have, and come and ask to be an amicus curiae in a South African court simply because he or she have some information that can assist the court? That's what I want you to address when you say it is of no significance, so that when we see and adjudicate on the matter, we then know that is there a prevention of anyone else who wants to be an amicus curiae in a South African court by an entity that is not even registered? Just address that one, and my apologies for interjecting.
As it pleases the court, your justices, the NGO not being registered does not deter them from being an interested party. Now, an interested party is somebody who can approach the court. Someone who can approach the court whereby they will be either directly or indirectly affected by the outcome of the judgment of the court, your justice.
Okay, you can reply to the other issues because I am aware that I may have disturbed your chain of thought. Just to bring you back, they have raised the issue of registration. They have raised the issue that says all what you have presented here is available information. There is nothing extraordinary about them that makes you, as an amicus curiae, say, I need to present this. Any response on that?
Your justices, with regards to the admission of the amicus in these proceedings, the discretion lies with the court. And if it is in the interest of justice that the amicus be admitted to these proceedings, then there is a decision that will rest with the court, and it is within the discretion of the court, your justices. Now, as the applicants, we are submitting that it is in the interest of justice that we have the amicus being admitted in these proceedings, simply because of the evidential material that they have at their disposal will play a vital role with regards to the outcome that this court will make with regards to the matters that we have before us here today, your justices.
Thank you. We would then have a 2-minute for a quick discussion so that we can decide whether we're going to pronounce immediately so that we can proceed, or that would require an adjournment. Order is hereby made, one, that the Amicus curiae, which has been placed before court by Safe Culture, is hereby refused. Two, there is no order as to cost. Three, the reasons for the refusal of the admission of the Amicus curiae will be detailed at a later stage when the judgment in the main matter is being made. With that said, then the issue of the admission of Amicus curiae is now settled. We now want to dictate how the process should proceed going forward. And I want to hear argument following the arguments on agency would be the arguments on directly approaching this court and not having to go through other processes. Must be had so that we can just the on agency. So you had prepared the arguments on agency, and I would as you are preparing to argue the matter here, if there is any different view or if there's any concurrence from my brother and my sister as to whether we should go in that route. Remember, they may have their views changed after our initial perusal of the documents. My sister?
I'm fine.
She's comfortable? My brother?
Yeah.
She's comfortable. Let's immediately hear arguments on why this matter should be heard on an urgent basis. Applicant?
As it pleases the court. Your Justices, Section 167, subsection 6 of the Constitution says that the Court must allow a person, when it's in the interest of justice and with leave of the court, A, to bring a matter directly to the Constitutional Court, or B, to appeal directly to the Constitutional Court from any other court. This procedure, Your Justices, is ordinarily permitted only in exceptional circumstances. Now, our main reliance is on the latter, and we have submitted an application in terms of Rule 19 of the Concord Rules to satisfy this procedure. Now, I must make it clear, Your Justices, that we are not asking for direct access to the Constitutional Court. We are asking for a direct appeal to the Constitutional Court. We are not asking the court to be a court of first instance. However, in this case, it will be a court of last instance, since it is the highest court in the land. So I just wanted to clarify that, Your Justice, that we are not submitting an application for direct access, but rather direct appeal to the Constitutional Court. And we are appearing before this honorable court as appellants.
Just on that note, it adds that intuition in me that says when I hear counsel present something that is different
from the papers that I have read, then come up and say, clear my mind. Is it your
argument.
Correct, Your Justice. It's paragraph 1 on page number 7 of the heads of argument.
Okay. Now, here is how my mind works. I had an opportunity to go through the other court before. Would that be the Eastern Cape Division?
Correct.
Right.
I don't know what is it that makes you say, I now want to surpass the Supreme Court of Appeal and I would want to go and hear the Bramfontein Court as we are normally called. Now, if that is the case, have you made submissions and or presentations in your heads of argument? Why are you surpassing the Supreme Court of Appeal?
As it pleases the court, Your Justice, to answer your question, we are bypassing the hierarchy of our court systems simply because this is an urgent matter that involves constitutional issues whereby people's fundamental human rights have been violated.
And when did those constitutional issues became aware to your team or to your client that makes you to immediately move from a provincial division, jump the highest court of appeal, and come to the last court of resort?
Can you just please rephrase your question, Your Justice?
These constitutional issues arise to you or to your client, that says immediately after the Eastern Cape Division made a ruling, I now acquire the right to go directly to appeal to the Constitutional Court, and I am surpassing you, the SCA. There, initially when you took your matter to the Eastern Cape, why did they immediately arise after the decision in the Eastern Cape High Court? That's where my loss is.
As it pleases the court, simply because of the urgency of the matter, Your Justice, on paragraph 5 on page number 9, I have made submissions with regards to the relevant factors that are considered for a direct leave to appeal to the Constitutional Court. Now, we became aware of these issues, Your Justice, when the applicants, the Shikleni Msenge community, were being evicted from their homes. They were unlawfully evicted at that. And we therefore went to the Mthatha High Court Division, and the ruling of the court, of the Korako, was not in our favor. And therefore, because of the urgency of the matter, we are seeking for direct leave for appeal to the Constitutional Court.
Counsel, you're referring us to your court bundle?
Correct.
Which we do not have in front of us.
I was not aware.
Given access to those files? I'm giving you a chance to now hand them up.
Guys, can you give them your... I apologize to the Honorable Court.
On a lighter note, unless if you were saying you had submitted them
Electronically.
because we did read them electronically. Sometimes we operate different. We want them hard copies.
Thank you, Your Justice.
Respondents, could you please also...
As it pleases the court, are you answered, Your Justice, with regards to your question?
Yes, proceed with your line of thought and argument.
Thank you, Your Justices. So, as I've said, Your Justices, on page 9, paragraph number 5, I've noted the factors that are relevant for applications for direct leave of appeal to the Constitutional Court. And they are simply just two factors. The first one is savings in time and costs, and the second one, urgency of having a final determination of the matter in the issue. Now, with regards to savings in costs and time, in the case of Dudley versus City of Cape Town and another, the court noted that it would consider whether savings in time and cost would result from a direct appeal. With regards to the urgency of the matter, in the case of Minister of Public Works and others, versus Kailami Ridge Environmental Association and another, the court held that although there were a number of issues with which the High Court did not deal with, which would be forced to adjudicate if it were to grant direct leave to appeal, the interests of justice demand that the dispute as to the legality of the transit camp that the government had established for flood victims, my apologies, at Luwekop, as resolved as expeditiously as possible. Now, with regards to the urgency of the matter, Your Justices, the respondents overlook the considerable financial and temporal pressures that would be placed on the community if they were obligated to traverse the entire judicial system. While the legal process is crucial for safeguarding rights and pursuing remedies, it unquestionably consumes time and incurs financial costs. By initially engaging with the High Court, the applicants were following the recognized judicial hierarchy and pursuing recourse through the proper avenues. However, the High Court failed to acknowledge the violations of the human rights, and the seriousness of the repercussions underscores the need for intervention by the highest judicial body. Your Justices, I just want to put emphasis on the fact that this matter is urgent because as we speak right now, the community of the Shiqene Msenge are currently homeless and have been evicted unlawfully from their homes. So as we speak, we are talking about a community that is on the streets and they do not have a place where they can lay their heads at night. So therefore, it is thus justified that this matter be heard by this court on a direct leave of appeal.
Having done that, you would note that you are left with 10 minutes.
I have concluded my submissions, Your Justice.
Yes, but there's just a few issues that I need
to address, and correct me if I'm wrong. You have dealt with the agency, you have dealt with the direct access. We still have issue number 1 and issue number 3. In a succinct manner, as best as you can address us. The question of jurisdiction, the question of the obligations of the South African government and the ministers in as far as the right to human dignity, and the protection of children's rights. Those are the issues that I think you need to quickly, in the last 8 minutes that is remaining, address us on, so that when the respondent gets their fair share of argument, you'll then have the right to reply, and we should be happy with your arguments. Are you ready to proceed? And are you still going to be the one who is presenting on behalf of the applicant?
As it pleases the court, Your Justice, I will just briefly address you with regards to jurisdiction. The rest of the issues, my co-counsel will be addressing the Honorable Court with regards to those.
Right. Bearing in mind the time that they have left.
Correct.
And I guess I am right that it is 30 minutes for argument in its entirety. So you have taken a chunk of the time and they will be remaining with a little. But I guess they would be able to present it as such. And if I am wrong on these time allocations, you can correct.
Thank you. Sorry, Counsel, before you proceed, I just want to make you guys aware, as mentioned in the rules of engagement, you must reserve time for rebuttals. Do you still wish to proceed in presenting your arguments, considering that there are issues that your co-counsel would like to present?
Your Justice, for the sake of time, I think it would be an honorable thing to do to seek the podium to my co-counsel so that they can also advance their arguments.
A quick minute.
Sorry?
Do you want to consult with them first?
No, I would like to cede the podium.
Oh, sorry, cede, okay.
To them.
All right.
Correct.
Is it fine?
As it pleases the court.
May it please the court, I am Counsel Mbali Shabangu. I will be making submissions on issues 3 and 4, which are contained on page 13 to page 24 and page 25 to page 27 of the heads of argument, respectively.
Yes, proceed, madam.
I'm appearing before the court on behalf of applicants 1 through 7, and I'll be drawing the court's attention, firstly, to the resettlement. Firstly, to the constitutionality of removals and resettlements of the communities, taking into account Section 25 of the Constitution, and secondly, to the obligations of the South African government and the ministers in as far as the right to human dignity to cultural, religious, and linguistic communities of the affected individuals concerned. On an introductory note, Your Justices, I would like to usher the court into an understanding of the components of this case, which is of paramount importance, not only to the individuals directly affected, but to every individual in the Republic, particularly those in destitute, living under the belief, the hope, and the expectation that their rights as enshrined in the Constitution will safeguard their livelihoods. This component, in this case, Your Justices, is the close proximity and in some cases direct links that this case has to a gross violation of fundamental human rights. And now to delve into the occurrences which prompted our appearance before this court, applicants 1 through 7 had their rights encroached upon by the 2nd, the 3rd, and the 6th respondent by granting the 7th respondent mining rights in the Bakang region, where the applicants and their community, the Shiklinimsenge community, not only resided, but where their ancestors resided for over 200 years. I will, in a different part of my submissions, draw the parallels between what rights were infringed upon during this time and why that infringement was unlawful and unjustified. Secondly, the 7th respondent then proceeded to hold an absurd make-believe consultation with the leadership of the community and coming to an ill-informed and negligent decision to commence with mining in the area. The 7th respondent then enlisted the services of the 8th respondent, who conducted forceful removals of the applicants in their communities, leaving them stranded without food, shelter, and water. These ordeals, Your Justices, have greatly affected the livelihoods of the applicants, along with their ability to enjoy their right to property as stipulated in Section 25 of the Constitution, rights to housing as stated in Section 26 of the Constitution, and the freedom of security as stated in Section 12 of the Constitution. Lastly, their ability to enjoy their right to freedom of religion and belief, as this land is where they carry out their traditional and cultural practices, which encapsulates the essence of who they are as a people. I will begin with the constitutionality of the removal and resettlement of the communities, taking into account Section 25 of the Constitution with regards to applicants, with regards to the application of the rule of law to the fact. Section 25 of the Constitution, the Property Clause, protects property rights and prohibits arbitrary deprivation. The removal of the Shiklinimsenge community raises concerns regarding the arbitrary deprivation of their ancestral land and emphasizes the need for constitutional examination. Section 26 of the PI Act, which is the Prevention of Illegal Evictions from Unlawful Occupation of Land Act of 1998, states that, or stipulates that rather, no one may be evicted from their homes without.
But let me say this to you.
Remember, we have electronically gone through all the things, and I'm not intending to disturb your line of thought. If you can summarize, due to time issues, if you can summarize and pick up the points that you most want to stress. We have read these documents and move to the next point. I'm sorry to be doing this. You are just going through what you've gone through. Stress where it is important as you move faster, because I hate to see cutting your argument without you finishing it. Thank you.
If I may correct you, Justice, I am not in fact reading from the submissions that you have. I am rather making a detailed oral submission which relates to the summary of facts that you have in front of you.
Thank you.
Thank you, sir. The forceful removal of the applicants from their homes and having them without shelter and water is a direct violation of their human dignity, which is contained under Section 10 of the Constitution, stating that everyone has the inherent right to have their dignity respected and protected. And I'm asserting, your justices, that the circumstances that the applicants were forced into strips them of that human dignity. It is held under Baleni versus Minister of Mineral Resources that companies must first seek permission from the local communities if they plan to mine on their ancestral land. In the judgment of Baleni versus Minister of Mineral Resources case, the court cited the Interim Protection of Informal Land Rights Act 31 of 1996, where under Section 2, subsection 1, it is stated that no person may be deprived of any informal land rights without his or her consent, which then, in the applicant's case before the court, declares that the Shiklanimsenge community have ownership of the land and may make decisions with regards to the use of the land. The court should also note that the judgment held in Maledu versus others, I beg your indulgence, Maledu and others versus Iterleng Bakhatla Mineral Resources, outlined and confirmed in its judgment that customary ownership is ownership in its own right. And as far as customary law is concerned, ancestral land belongs to the future generations. This expresses that the Sangha community owned the land and nullifies the fact that the respondents, or the company rather in the respondents, were given mining rights while the applicants were not residing in the area. Furthermore, customary land tenure is not normally based on codified statutory sources, but stems from customary tradition and norms. The Shiklanimsenge community hold a divine connection to the Bakang region. And by divine connection, I mean, 1, their loved ones are buried on the land. 2, they engage in practices concerned with tradition and culture, which they carry out with the help of the rivers and ravines that are available in the area, as the water is a spiritual element that connects them to their ancestors. And 3, they use the land and water sources for subsistence farming. These practices, your justices, are practices that the community has the right to perform and the right to be protected under Section 31 of the Constitution, covering cultural, religious, and linguistic communities, which state under subsection 1 that persons belonging to cultural, religious, and linguistic communities may not be denied the right with other members of the community to enjoy their culture. This assertion means that the 7th respondent is in direct violation of the applicant's constitutional right. It also means that the South African government and the ministers of mineral resources have failed dismally to protect the applicants and their rights to meet the obligation to protect the client unlawful practices by the 7th respondent. The intended or proposed relocation of the graves fails to meet any of the stipulated procedure, which is stated in the following legislation. 1, Section 52 of the Cemetery and Crematorium Bylaw that states that human remains may only be exhumed if 1, the Premier, the General Attorney, or the Magistrate and the reservation certificate holder authorize the exhumation in writing. 2, the National Heritage Rescue Act 25 of 1999 states that permits to exhume cannot be issued unless written evidence is supplied that a concerted effort has been made to consult with the next of kin or the communities of the interested parties in the remains. Your Justices, there has been no record of the respondents making an attempt to follow such stipulated procedure. And finally, Your Justices, I would like to plead with the Honorable Court to consider that there are lives in the balance and that the ramifications of this case will have overarching consequences. I would now like to cede the podium, if the judges have no questions, to my co-counsel Kaya Matala.
Yes, proceed, Advocate Kaya. Is it Motala or Matala?
Matala.
Matala.
Yes.
The floor is yours. We've been waiting to hear your voice.
Okay. Your Justices, may it please the Court, my name is Kaya Matala, Counsel for the applicant. My submissions are on issue 5, 6, the prayers and the costs. If it pleases the Court, I'll first delve into the contentions based on issue 5 and thereafter notify the bench before presenting contentions based on issue 6 and the prayers. As it pleases the Court, issue 5 of this matter is the constitutional obligations of the Eastern Cape with regard to the provision of alternative housing. Section 26, subsection 1 of the Constitution states that, open quote, everyone has the right to have access to adequate housing, close quote. Subsection 2 states that the state must take reasonable legislative measures within its available resources to achieve the progressive realization of this right. Your Justices, the Eastern Cape Department of Human Settlements has the vested powers to achieve this right by Section 125, subsection 2B of the Constitution, which regulates provinces' assignment of functions, and Section 4 of the Constitution, which lists housing as one of its functional areas of concurrent national and provincial legislative competence. Section 2, subsection 1A of the Housing Act 107 of 1997 states that national, provincial, and local spheres of government must prioritize the needs of the poor in housing development. This legislation proves that there was indeed non-fulfillment of constitutional obligations by the Eastern Cape with regards to alternative housing when they left the Shetini Msenge community in destitute, as seen in paragraph 2.12 of this matter, whereby it was cited that the forceful removers who were hired by the IAMC to conduct a forceful removal of the Shetini Msenge community from the ancestral land left the community, including the elderly, disabled, and children, stranded without shelter, food, and water. Section 7, subsection 1 of the Housing Act additionally states that every provincial government must, after consultation with the provincial organizations representing municipalities as contemplated in Section 163A of the Constitution, do everything in its power to promote and facilitate the provision of adequate housing in its province within the framework of national housing. Your Justices, taking an observation on paragraph 2.3 of this current matter, which reads that the legislative requirements for the application and granting of the mining right were all complied with, and as such, the IAMC was granted a mining right. However, there is no record of public participation initiated by the Eastern Cape Department of Human Settlement. Your Justices, the community was supposed to be meaningfully engaged as stated in the case of Port Elizabeth versus various 2004. Courts, where this very court, the meaningful engagement is a requirement to interdict and even perhaps resolve disputes. I beg your indulgence. Department of Human Settlements was obliged to provide the alternative housing for the Shikinimsenge community. This duty was also emphasized in paragraph 96 of the City of Johannesburg versus Blue Moonlight case, in which the city was ordered to provide the occupiers with temporary accommodation 2 weeks before the date of eviction to ensure the occupiers would not end up homeless. Your Justices, in this matter, the obligation to provide alternative housing is on the Department of Human Settlement through the Minister, since it is cited as the fifth reality on the national level is to assist provinces and municipalities with comprehensive planning for the upgrading of informal settlements, which involves providing secure turner, safe and reliable water, sanitation and adequate access to social services. May it please the court. That concludes my contentions on issue 5. Yes, Your Justice. The next issue that I'll be submitting my contentions on is issue 6.
The prayers and the cost with time against you, what should this court do? You seem to be wanting to, unfortunately there's something red on your left. I'm not sure whether time management says we should end it here.
Okay.
And unfortunately, maybe somewhere at a later stage you'll be able to answer this. But before you take your seat, my brother wants to engage some aspects of your argument.
Okay. Yes.
That you are bringing the Department of Human Settlement,
yes,
as the fifth respondent.
Yes.
And this issue, from the facts, and please tell me if I'm wrong. It is this company which wants to but you are saying that the Department of Human Settlements was supposed to provide accommodation. How do they come in?
Your Justice, as it pleases the court. Where's the fact?
Because these people were having a community, and they were settled, they were happy there, and I'm not sure whether there was any consultations with the Department of Human Settlement and any ruling on where these people must be relocated. But now you are saying these people must respond when the community was settled. How does the Department of Human Settlement become part of these proceedings?
Okay. Your Justice, as it pleases the court, the Department of Mineral Resources and Energy are equally liable with the IAMC. Oh, okay. Okay. Pleases the court. The Department of Human Settlement is liable to provide alternative housing for the Shikinimsenge community who has been left in destitute based on Schedule 4 of the Constitution, which lists housing as one of its functional areas of concurrent national and provincial.
I'm sorry, I hear that.
Yes.
Like I said, these people were a community. they were settled, everything was fine. Now some company come, they want to mine, they went to apply for a license from the Department of Mineral Resources. And you are saying now should come in and provide accommodation for these people. So every time a company wants to mine, then the Department of Human Settlement must just come in. Is that what you're saying?
Your Justice, for the sake of time, I was going to delve into the issue of reviewing and setting aside the mining right, which is why the Shikini community is now left without shelter. Should the had the Department of Mineral Resources and Energy consulted with the Department of Human Settlements to provide housing for the Shikini community, they would have not been left in destitute. But because now they're left in destitute, it is now the responsibility for the Department of Human Settlements to take over and not leave the Shikini community stranded without shelter. May it please the court.
Okay. The question was more of a clarity seeking.
From my brother, that
doesn't mean we should extend it more. We will still have our opportunity to reflect on your argument. Unfortunately, time is not on our side anymore. We want to thank you for your presentations as the applicant. We can't hear anything from you. But before I get to the respondents,
to start presenting their side of the story. And on a lighter note,
do you know something called load shedding?
Yes, Your Justice, I do.
I guess you know what I'm talking about.
Yeah.
If it was to happen, where would you be? You missed the point.
The response time starts now.
As it pleases the court, I beg leave of the court to proceed with submissions.
I believe advocate
It's Amelia Kekan.
Amelia Kekan.
Yes.
Okay. Just before you proceed, we're just dealing with an administrative issue of the scorecard.
And I forgot to ask this to Advocate Kekana as well. Are the two Kekanas before this court somehow related to Steve Kekana by any chance?
We are not. I'm not. I don't know about him.
Okay. Advocate Jeremiah, any relation to the legendary Steve Kekana?
Not at all, Your Justice.
Okay. Do you know one of his songs? Do you know one of his songs?
Amelia, Advocate Amelia?
No, I don't.
You are not related to me. Thank you. You can proceed and argue your matter.
As the court pleases, I will be dealing with direct appeal to the Constitutional Court and jurisdiction. If it pleases the court, I beg leave of the court to proceed with my submissions. The respondents submit that it will not be in the interest of justice for the court to grant direct appeal to the Constitutional Court by the respondents. Firstly, As the respondents, we submit that in the case of member of the Executive Council for Development Planning and Local Government, Gauteng versus Democratic Party, it was held that in deciding what is in the interest of justice, each case has to be considered in light of its own factor. In light of its own facts. A factor will always be that direct appeals deny to this court the advantage of having before it the judgment of the Supreme Court of Appeal. In deciding whether it is in the interest of justice for the court to grant direct appeal to the applicant, there are certain factors which have to be taken into account. That is the agency.
Counsel, from your bundle, which page do we get the respondents? I got it. Thank you.
After file divider at the back.
All right. Thank you. You may proceed.
As the court pleases. There are factors which has to be taken into account in determining whether the Constitutional Court should grant the applicant's direct appeal, which is the agency of the matter and the role of the Supreme Court of Appeal and the High Court. Firstly, Section 168, subsection 3 of the Constitution states that Supreme Court of Appeal may decide appeals in any matter arising from the High Court of South Africa or a court of similar status to the High Court of South Africa, except in respect of labor or competition matters to such an extent as may be determined by the Act of Parliament. Furthermore, Section 168, subsection 3, paragraph B, Roman figure 1 and 2 states that the Supreme Court of Appeal may decide only issues connected with appeals. The applicants are bringing this matter to the Constitutional Court based on appeal. We submit that the Supreme Court of Appeal was the appropriate forum for the applicants to appeal to. The applicants should have approached the Supreme Court of Appeal as it is empowered by the Constitution to hear appeals and matters related to appeals. The applicants have provided no reason why they should bypass the Supreme Court of Appeal. They cannot base their contention on the fact that their matter is urgent, which moves us to the fact of agency. If the applicants allege that the matter was urgent because children, women, and the disabled are left on the streets, the respondents submit that the applicants were provided alternative residents.
Advocate Kekan, I'm sorry, I had indicated when the applicant was arguing that Ahmed, who when he hears things, he needs that to be clarified. And I see you are going along the lines of saying there is no agency. Correct me if I am wrong. Wouldn't the removal of minor children, elderly people, in an eviction that I perceive to be more of an economic-based kind of the mining issue, wouldn't that be urgent, whether before the Constitutional Court? Eviction that involves minor children, the elderly. I don't even want to go into what IX provides, but I hear you are saying there is nothing urgent. That sort of puts me in a discomfort position. You seem saying there's no agency.
As the court pleases, the respondents submit that the respondents provided the applicants with alternative accommodation, which implies that the respondents they cared about the rights of the children, the rights of the disabled people, and all the parties which are implicated in this matter. Therefore, if the applicants alleged that their matter was that urgent, they would not have disagreed to the relocation settlement that was provided by the respondents.
Okay, you can proceed with your.
As the court pleases. The respondent further submit that it will not be in the interest of justice for direct access to be granted for the applicants, in a sense that the Constitutional Court is the highest court in all constitutional matters. Therefore, the decision that the Constitutional Court will grant, it will not be in the interest of justice, because the matter, if ever the Constitutional Court, the Constitutional Court finds in favor of the applicants, the respondents will not be able to further appeal.
Again, you remind me of another recent case that happened in the shores of this country, wherein the former president of this country had approached the court on an urgent basis, seeking direct access. With that said, what are access?
As the court pleases, the respondents submit that in our case, referring to the case of member of Executive Council for Development Planning and Local Government, Gauteng versus Democratic Party and others, there are factors which have to be considered in determining whether it will be in the interest of justice for the Constitutional Court to grant direct access. This includes the urgency of the matter, the saving in time and cost which might result if direct access is allowed, and the prospect of success in that regard.
Let's also turn the coin around. If this court is not inclined to grant direct access as you are submitting, would there be any prejudice? I know that this aspect was not canvassed earlier with the applicant. I'm saying, because you are not going to have the second bite on the cherry, if this court is inclined to want to consider the question of prejudice, what are your views on that aspect?
As the court pleases, may you justices simplify the question with regard to the word? You said prejudice. In simple English term.
I'm not sure, maybe my sister can insist on. Okay. Prejudice would mean the following. What harm would occur if direct access is not granted? Because remember, once we have granted direct access, then it means we must pronounce and give a ruling. But if we do not grant direct access, we are refusing them to entertain their matter, and it means it must either revert back, or we must decide on the merits, or we say it goes to the Supreme Court of Appeal. You having assessed the facts of this matter, what then would the applicant suffer as prejudice in the event that we do not grant direct access?
As the court pleases, if direct access will not be granted, the applicants will not suffer any harm, because they can still take the matter to the Supreme Court of Appeal, which deals with appeals, because that is why they brought the matter. They want to appeal. Therefore, if direct access is not granted, they will not suffer any harm, because they can still take the matter back to the Supreme Court of Appeal, which can deal with their case.
Direct access is also linked to agency. That is why when they argued it, they were going hand in glove. So if we refuse them direct access, are you saying there is no agency? Then the matter must be taken back to whichever court, which court will also have to deal with the human rights issues that they have raised. And this court somehow has got the powers to can pronounce on constitutionality of certain issues. That is why I'm saying, what prejudice will they suffer And I don't intend arguing further with you. These are just concerns that I had. You can proceed arguing your matter anyway.
As the court pleases, I will now move to jurisdiction. The respondents submit that it is not in the interest of justice for how even though the Constitutional Court has jurisdiction to hear the matter, it is not in the interest of justice for the court to adjudicate on this matter because firstly, the respondents submit that the central issue in this case is centered around constitutional issues, which we do not dispute. And also, the central issue in this case, it is centered around the appeal. Therefore,
Counsel, maybe let me put the question in this way. The applicants have argued for direct access and the fact that this court has jurisdiction to hear the matter. And you are saying the court does not have jurisdiction. Am I correct?
no.
So you're saying the court has jurisdiction to hear this matter?
The respondents submit that even though the Constitutional Court has jurisdiction to hear the matter, it will not be in the interest of justice for it to adjudicate on this matter because they are bringing the matter to the Constitutional Court mainly based on the appeal, which can be dealt in the Supreme Court of Appeal.
So
Had it been that...
I get you. Now my question is, if we decide to hear the matter, what harm would it cause to you as respondents? If we decide to hear this matter, what harm will you suffer? What harm will your clients suffer if we decide to hear this matter? Because you are saying that it's an appeal matter, it should go to the Supreme Court of Appeal. But let's say we decide, no, we feel that we want to hear this matter. What harm will your client suffer by us adjudicating on this matter?
The respondents submit that if the Constitutional Court grants jurisdiction to hear this matter, they grant jurisdiction to hear this matter and they favor the applicants, it will not be in the interest of justice for the respondents
will not favor anyone. Let me correct you on that one. The court will not favor anyone. It will listen to presentations by both sides and then it will make a ruling based on what was argued or presented before it. So I'm repeating the question again. You are representing the respondents. The respondents is the President of the Republic of South Africa, the companies which are involved there, the community, and so the Department of Mineral Resources, Department of Human Settlement. So my question is, if we decide that we want to hear this matter, what harm will your clients suffer?
Our clients will suffer because they will not be able to appeal the matter since it will be in the Constitutional Court. However, if the Constitutional Court decide to adjudicate on this matter, then I would now beg leave of the court to
So
for
something that the will be a possible need for you to appeal that.
Can you repeat the question?
Because you are saying that your clients will forfeit the chance of appealing should be that situation where they need to appeal. You are saying they will have to forgo the opportunity to appeal. Therefore, they must go to the Supreme Court of Appeal, which you think that your clients may lose it. So when they lose it at the Supreme Court of Appeal, then they will have to come to that is when they will have to come to the Constitutional Court. That's what you are saying.
Yes. If I may further assistance, I beg leave of the court for Mr. Counsel Mokwena to proceed with his submissions.
Thank you. I've been waiting to hear Mr. Mokwena.
As it pleases the court. For the record, I'm Mr. Mokoena, and I'll be dealing with issue number 3, 4, 5, 3, 4, and 5, which is the constitutionality of the removal and resettlement of communities, taking into account Section 25 of the Constitution, the obligations of the South African government and ministers in as far as the right to human dignity, and the constitutional obligations of the Eastern Cape with regard to provision of alternative housing.
On a lighter note again, Mr. Mokoena, you know, everyone else has faced questions pertaining to their surname. On a lighter note, any relation to the Sundowns Mokoena?
Your Justice, I'm not actually really sure. I'm not familiar with my family tree and my family to that depth, but...
Okay, but do you know Teboho Mokoena?
Yes, I do know Teboho Mokoena, Your Justices.
Okay.
Yes.
Thank you.
As it pleases the court. I beg leave of this court to continue with my submissions.
Pleasure.
As it pleases the court. Regarding issue 3, Section 25 of the Constitution sets out that no person may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. Section 5, subsection 3, paragraph E, satisfies the first requirement dealing with law of general application, since it affords mining rights holders, in this case the IAMC, the 7th respondent, the option to carry out activities incidental to mining. The provision read with Chapter 8.8, Regulation 1 and Regulation 8.8, subsection 3, paragraph C of the Mine Health and Safety Act 29 of 1996 satisfies the requirements of law of general application. The two provisions read as follow. 8.1 read as follow. The employer must take reasonable practicable measures to prevent persons from being injured as a result of them, the clothes being worn by them, or any equipment being held by the coming into contact or being drawn into any moving part of a machine. 8.3 subsection 3 reads as follow. The measures to be taken by employer in terms of Regulation 1 must include measures that ensure that, subsection C, only persons authorized by the employer to do so enter any area where machinery is operated, where such operation may pose a significant risk to any person. For the relocation to be unconstitutional, it has to be arbitrary. In paragraph 11 of the case Lafoy versus Department of Justice and Constitutional Development and others, the court held that an action is only arbitrary if it is whimsical or based on random choices or personal whim rather than any reason or system. Furthermore, in the case of First National Bank SA Limited / West Bank versus Minister of Finance, the court held that for arbitrary purposes. Apologies. In the case of SA Limited / West Bank versus Minister of Finance,
Advocate Mokoena.
Yes, Your Justice.
Just take a breather a little bit. And I'm going to ask the same question that I had asked on the other side. Just out of my observation, have you ever heard of load shedding?
Yes, I have, Your Justice.
Okay. So when you present, it shouldn't be that, as your colleagues were doing, you always read what is on the document. If it is something that is readable, submit it, file it for our own reading when we're going to consider judgment. But to come and present matters and argue by reading to us something that we can read, then it takes away the purpose of us being persuaded by you adding what you have done. So is what you are reading from something that we can be able to read, or it's something that you have prepared as your note for you to address the court on?
As it please the court, to answer your question, Your Justices, the reading part is just a follow-up on the researches that I've made to keep up with my thoughts and what to say, not to say, because I might get my facts all mixed up. That's the purpose of my reading, but as I try to engage with you as much as I can, as it please the court.
Okay, proceed, but I must also, together with my brother and sister, be able to follow you, because that's the disadvantage of reading a document or reading a note without us even being able to interact with you.
As it please the court, it was
All right.
it is understood,
Sure.
Your Justices. I beg leave of the court to continue with further of my submissions.
Proceed.
As it please the court. As I was saying, for the relocation to be unconstitutional, it has to be arbitrary. In paragraph 11 of case of Lafoy versus Department of Justice and Constitutional Development, the court stated that an action is arbitrary if it is whimsical or based on random choice or personal whim rather than any reason or a system. Furthermore, in the case of National Bank SA Limited / West Bank versus Minister of Finance, the court mentioned that Deval et al. Are of the view that deprivation is arbitrary for the purposes of section 25 subsection 1. It follows unfair procedures if it is irrational or is of no good reason, meaning if ever a person or a company, in this instance the IAFC, relocated and removed the community of Shekin Musenge without any valid reason, then the action would have been arbitrary, and the resettlement and the resettlement would have been unconstitutional.
Maybe just on that point, it is also my reading of the documents before us that the mining activity of your client had stopped for a period of about 9 years.
As it please the court, true.
How do you, and I hope people won't look out at the dictionaries here, how do you juxtapose that argument with the fact that the removal happened with a 9-year period of non-activity? And I'm not sure of my brother and my sister, I'm also not so certain as to whether, as at when the time you had stoppage of mining activities, whether were those still at the stage of a prospective right, or were still at the stage of maybe a temporary or a short-term mining right being granted. But just juxtapose these for my understanding, because you have been going on and on the issue of arbitrary relocation. Just address me on those issues.
As it please the court, Your Justice, according to my understanding of the set of facts, the temporary pause of the mining activities that happened within the period of 9 years, it happened whereas the land was vacant and nobody was staying there. The community of Shekin Musenge was staying in the northern part of the Bokang region, not the exact same land where the mining has to be occurred. Indeed, we do agree that the whole region belongs to these communities, but the specific location where the mining was to occur.
Let me interrupt you. We're talking about forced removals. So why would people be removed if come here and argue that where the mining is going to take place, there were no people staying there? Why about forced and all these things.
I beg your pardon, Your Justices. I can't hear you.
I am saying according to the facts here, there is evidence and videos of people being harassed, intimidation, and forced removals.
Correct, Your Justices.
And I hear you arguing that in this 9 years period, there was no one who was staying in this place where this company wants to mine.
If I emphasize my answer correctly, the 9-year period whereby the company had stopped the mining processes, during that period of 9 years, the community of Shitinga was staying in the northern region. So during the period of that 9 years, they relocated to the exact same land, whereas the mining processes was still paused due to
the process, yes.
Yes, was still paused due to the machinery contract that they had with other company, meaning they had they followed each and every procedure they can. They did everything by the law and by what is expected of them. So it happened that there was a misfortune when they had to start the mining procedures.
I hear that. So how do you justify these forced removals? How do you justify them?
We were to just, as it please the court, I were to, counsel for the respondents were to justify the forced removals, firstly by stating that the mining company had acquired the land, had mining rights to mine the right before people were evicted. If you may please the court, I'd like...
The mining rights, does that justify them having to forcefully remove the people?
If you please the court, I'd like to consult with my co-counsels for a minute. As it please the court,
you might not even enjoy that opportunity. Did see what happened on your left?
Yes, Your Justice, I did see what happened on my left.
Did you?
Yes, Your Justice.
Okay, for the sake of fairness, maybe respond to that, and we will grant you maybe extra 3 minutes to wrap it up.
Please the court. To justify the forceful removals, firstly, the people were given consent that they need to evacuate, but rather they did not evacuate, and they said they are not living anywhere. As a place to the court, that is correct, Your Justices. That's why the respond.
So the respondents, they do that?
Yes, as a place the court, the respondents did them offer alternative accommodation at the nearest city center, where they will have access to every basic need services they need.
Okay. In the 2 minutes extension that we gave you, and because you're no longer going to have an opportunity to can address us on the merits of the matter, only the applicant is having the last bite in terms of the nature of argument.
Correct, Your Justices.
And I'm not sure who's going to answer this, unfinished conundrum that remains in my head. But please do answer it as best as you can, or one of your colleagues can answer it. I sit here and I listen to the crux of this matter. I note the jurisdiction, I note everything else, the agency, the direct access, the constitutional rights, and the cost issue. like I have been asking you as to whether you know the Mukwenas, I asked them whether they know the Kekanas. Maybe that also brings down to me to disclose that I do understand the tribes that you come from. So, to the point, right? I understand this matter to be a battle of economic rights that someone else in your client be granted.
Correct, Your Justices.
Processes were followed, Department of Mineral Rights, prospecting and whatever was granted.
Correct.
That's in a nutshell the contention of your client's case. I understand the applicant case to be saying, in this battle of the economic rights to enjoy one of the constitutionally enshrined rights to run business, here are people on the other side. Others are unable to practice bongaka babona. There are a whole lot of things that they are crying about. You would note that the first applicant has outlined what kind of life he lives out of this land. So it's a land question basically. So economic rights that you want to protect for your clients about iron ore, which your client has enjoyed for the last 10 years, some good benefit out of it, versus the human rights that the applicants' various clients, including the communities, are saying Constitutional Court decide these two issues, human rights versus economic rights. Can you address this court on that issue? I know you may have not an argument on it, but it is something that arises out of this court's concern to say, this is where the crux of this matter is. Iron ore, money, yes, you wanted to open a school for the blind somewhere else, but we see it as benefiting some sectors. Whilst Dingaka Kamudia Sokola, they want access to rivers and so forth. Just address that aspect.
As it pleases the court, it is indeed that this matter it's a matter between economical issues and economical business rights and human rights issues. But in this instance, our clients did follow the IAMC, did follow each and every procedure that was expected of them. Did the IMAC did actually in fact go to the ruling, to the rulers of the Vogang region, whereby they had to ask for land to mine where they had to ask for permission to mine the land. So the problem lies with the one of the community members misinterpreted themselves for being the person who they are not, or having the authority that they're not, whereas it is a criminal matter whereby the community itself failed.
Agreeing for the appellants. The argument that you are putting before us, it's something that should be argued by the appellants, not you as somebody representing the respondents. So what do you want us? Can I maybe offer you an opportunity, just 30 seconds, to consult with your colleagues?
Asking, there is a difference between human rights and economical rights, right? If there is some economical rights, they will benefit the community.
And when you are also allowed, to come in, if you feel that you can assist your
Except, do you
want to answer it?
Whilst they take the opportunity to confer with each other, be reminded that you have 5 minutes to reply. The way that you're nodding your head, Advocate Kekan, it looks like you have been ready. Okay. No. I was just saying, that's why I'm saying the way that you nodded your head, you are ready to fly. I was just saying, be prepared.
What's happening?
Starting is asked on the question. So basically when we are answering that is that the economical rights will benefit the community of when we are relocating the community to a city center, we are actually giving them an upgrade of life. This will actually give the people who were disadvantaged, indigenous people who are not getting any access to clean water or a better education or even a healthier environment. Taking them to an upgraded city center where they will have access to all of those things as it pleases the court.
Thank you for the submissions, respondents. Remember, we had just wanted you to answer this question, which my brother also just dealt with. Thank you. We're now moving to the last 5 minutes of the applicants responding, and be cautioned, Advocate Kekan, responding to the arguments that have been made by the respondents. So you are rebutting that. That is why the word, your right of rebuttal, was used. The floor is yours. 5 minutes.
As it pleases.
During the first time when you...
Your Justices.
During we are all ears.
As it pleases the court, your Justices, I just want to start with the arguments that they've raised. They firstly said that the applicants should have moved into the alternative housing that was provided. Now, we submit as the applicants that moving into the alternative housing would be playing right into the hands of the respondents, in a sense that it would undermine the issue of urgency that we have already advanced in our submissions. Number 2, the applicants did not consult to being removed. They did not consult to being relocated, and they've advanced arguments to say that that was the case, and that was clearly state that the community was left stranded. Number 3, made submissions with regards to the jurisdiction of other courts. Your Justices, I just want to bring to your attention Section 172 of the Constitution, which says that the decisions of the lower courts are bound to be confirmed by the Constitutional Court. So meaning that even if we were to appeal to the full bench of the High Court and we were to appeal to the Supreme Court of Appeal, eventually the matter would have to go to the Constitutional Court, because matters that are concerned with constitutional issues are bound to be confirmed by the Constitutional Court. Your Justices, my colleagues here made arguments with regards to consultation. They say that the community agreed to the relocation. However, this was not the case. I want to state that in terms of Section 10 of the MPRDA Act, the community was not meaningfully consulted, as they should have been. Mr. Nkopodi misrepresented himself and consulted on behalf of other people that he himself did not consult with. He therefore acted out of his own personal interest. Your Justices, last point. The respondents did not address the ownership of the land, and they did not address the unlawful evictions in terms of Section 4 of the PI Act. That I just also want to quickly, of course, while time still allows me. With regards to the costs, Your Justices, in the event that we are successful in these proceedings, we are asking for costs on an attorney and client cost scale. And we are relying on the BioWatch principle as a precedent for asking for those type of costs. In a nutshell, Your Justices, the principle of the BioWatch establishes that individuals or organizations acting in good faith and in public interest, particularly in cases involving constitutional rights, may be entitled to a cost order against the respondents who have violated their rights.
Aren't you taking that issue of costs too far, Advocate Kekana?
I've concluded my submission.
No, I'm just saying, I'm not saying withdraw your submissions. I'm saying, aren't you taking the issue of costs too far? When you say BioWatch is applicable and that they must pay costs on an attorney and client scale. By the way, I'm going to afford the respondents to answer or respond to that issue because it was never argued before. I was just saying, aren't you taking that aspect too far?
We're just cementing our submissions, Your Justice, to ensure that.
Before the respondents respond to the issue of cost on an attorney and client scale, I thought, and this is on a lighter note, I thought you were going to say, when they argue that relocation is going to be closer to the city, you would maybe respond and say, Metsi ano ka betere than allocation. But that's fine. Your response only on the question of costs. They are arguing that you must pay costs on an attorney and client scale, meaning you must be punished for defending this matter. That's what they are saying.
Your Justices, applicants are liable for their own costs. Considering the prolonged court proceedings the applicant had to encounter, as it pleases the court.
Okay. Is that all? All right. I just need to have a quick deliberation with the fellow brother and sister so that we can tell you what is going to happen from now henceforth. The deliberation has come up with the following conclusion. I guess the mere fact that it was as short as it was tells you where it is going. I see a smile on the right and I don't see a smile on the left. I'm saying the mere fact that the deliberations were as short as they are tells you where the judgment is going. In any way, we want to thank you for the presentations that you have made, both the applicant and the respondents. And by virtue of us needing more time to look into the arguments which were indeed persuasive, we're not going to be able to give judgment immediately. Hereby reserved. Thank you. But
And the participants will have to sit in.
Still waiting. We don't know. They need their hands off.
Why do they need them?
For the next courtroom.
Oh.
Is it not?
But wait. Mina, I have.
Oh, what? You must remember from memory.
No. I know how they argue somehow.
Okay. And then we have to discuss them.
Unless we might end up shuffling his judgment. Sorry, madam.
Okay, wait, madam. This thing is all the same. It's for 6. It's for 6.
Good afternoon, colleagues. My name is Justice Tim Banza. Besides me, I have
Armpela.
As Poshoko.
Thank you, colleagues. We are calling case number 1 of 2023 in the matter of Themba Maluleke and 6 others versus the President of the Republic of South Africa and 7 others. May I kindly request that the applicants place themselves on record individually, please.
Good day, Justices. Good day, Justices. May it please the Court. My name is Maria Nkomo, and I'm the first counsel for the appellants.
Good day, Justices. My name is Alan Tim, and I'm the second counsel for the appellants. Someone. Delanim Tim.
Delanim Tim.
Delanim Tim, please.
Thank you, Counsel. Counsel Makolo, may you please repeat your surname again, please, ma'am? D-A-H-I-L-E. The first app, thank you, ma'am. Counsel, Maria Nkomo is correct. Nkomo. And Delanim Tembu. Okay. Thank you very much, colleagues. Apologies about the delay there. We are just having a few preliminary issues. Colleagues on the respondents, may you kindly place yourself on records?
Good day, Your Justices. My name is Leah Unalena-Sevole.
Oh, it's on. I think it's on, yeah. Good day, Your Justices. My name is Leah Unalena-Sevole, and I'm the first counsel for the respondent side.
Good day, Justices. My name is Karabo Pilani, and I'm the second counsel for the respondent. As the Court pleases.
Good day, Your Justices. My name is Ramhodze Moekwa, and I'm the third counsel for the respondents. As the Court pleases, Your Justice.
The previous round for which you were for the respondent, and you were for the applicant. So you switched.
Next door. Okay, let me try that. Because they were saying that you guys were responding. But
Northwest. Yes.
The two differences, no, this one doesn't have anything.
Yeah, then that would be. Yes, then 6. So I've got 3 C.
All in all, we must have 8. So does it mean 4?
I think you have 16 if you include. Oh, that's right.
Okay, then this one. I didn't need 2 amendments. 1, 2.
Oh, yes. No develop 5. Impel 1
Making
is.
that 8.
Impel 1. So, you know, I think
I think. Do you need anything? Addendum, but.
Can I have an example?
Yeah.
This one.
Test 1 2 1 2. Okay. Testing mic. Testing. 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 Okay.
Guys, let's improve. We can ace this one. You want to look unlike Kabili. Kabili looks very big. Smiles at one and town. He just looks at you and then he speaks to you privately. So what do you everyone? I told you. It could work to your advantage. But the thing is that if he's not yeah, that's the thing. But it sucks that he doesn't pay attention to what you're saying.
Yeah, goodbye.
Based on,
I've got 2
other aspects. And it's not fair, because you're not losing just because other.
Oh, these are the right.
Everything is fine.
Let's just take the names and then.
Yes, so
I don't know. Hello. Yes. I don't know. Yeah, you have to come with the previous ones and then.
Can I move it?
Just to get the same. Maybe Baratama with this. This one we can spare.
Okay.
That's fine because they are here. Where's my thing?
No, the judgment, the other one on the class.
We were judging Jovet and okay, let's start there. Maria, is it who? Nkomo.
Maria Nkomo.
It's NKMO. Okay, let's make sure. And then Mtengu, okay, I don't. Yeah, what age?
Yes.
Okay. And then not call or Tahile.
The applicants,
Yes, those are the applicants. Kuruleni.
So you're going to address in that order?
Yes, first, second.
So let me respondents. Lea Sebole. Sehole. H? S-E-H-O-O-L-E. And then Karabo P. P-I-L-A-N-E. Okay. And the last one will be Moekoa, M-O-E-K-O-A. Okay, I've not seen now. I think she said M-O-E-K-W-A. Thank you. Okay. Trust them. This is your head, let's see. This is someone's view. That's for the previous one. Okay. Check housekeeping issues. You all have heads?
Yes.
Head.
Our head, and then the respondent's head.
This arm?
No, those are not ours.
May I approach?
I think these are the ones that I have.
No, I don't know.
So who's coming here, Nisha? But we were with Johannesburg.
This is.
Ma'am,
We were with Johannesburg.
Johannesburg.
We were with Metroburg and Johannesburg previously. Here we are fine. We meet them for the first time.
Yeah, there's an issue elsewhere then.
Oh, you were a code D. So you are supposed to be.
Yes.
Oh, what is that? What is
Hey, when you're proactive, already we're picking up immediately.
This is
Oh, okay. So you're not giving us each a file.
Thank you. This is
Yeah,
when
no, but
you were on the other side.
Oh,
This is
so this was
No, you please leave it like this. We are fine. We are fine.
Is it for the Northwest? Yes. Applicant.
Hi,
Are we?
we are supposed to be
No.
There's an
sorry.
issue elsewhere.
We had this group on the 10th floor. Michelle? We've always been fine.
Michelle, you know, even now we're still fine.
Even there on the 10th floor when you moved
Never
us,
had
we were
issues.
fine. We always moved people.
I'm just doing what I'm being told. See, I'm being given this list.
But we were with Joburg previously.
I think Mr. said they're going to change you, but she needs to make sure that the teams are okay first. And the ones on the 10th floor, I think they're almost done.
They're
They
supposed
need
to be
stop.
different with the different.
Yes.
So
So
were
the
you
problem
together
was,
and the
no,
previous okay? No,
they
no.
were not
fine the way-
together, but if we leave them, there's still going to be two teams that are going against each other, and they were against each other before. So that's why they are swapping.
Give the issue with the two teams, basically.
Yeah.
Yes.
Not here. Because here we don't have
You, which team were you adjudicating with?
Joburg and Middleburg.
It's still Middleburg next door, so no.
So we're going back up.
To which teams?
Up
Where we
there
were?
is Court C, which is
That's
Polokwane and
like
Cape Town, and Court D, which is Ekurhuleni and Pretoria. Which means Advocate Gavin, I think, will have to come here.
Because this one is
Yes.
There's a mess up with another team. Which
These guys are going against Pretoria in the same competition.
I'm trying to understand the confusion. To say there's two teams that are going
But they should have done this
where they just won. And every other team was fine because we are 8 teams. So you can still do the swapping and one team can still be messed up. So that's how it was.
But we are fine here, most. We didn't see them when
You need to go to court to see it, otherwise court will start
and now
telling
you're gonna
you.
tell us to come because this is like the 4th time this is happening. You're gonna tell us to come here.
The problem was Joburg.
Then they should swap.
They didn't say anything until one of the guys remembered
They are yours.
We did.
They are done. They've signed it.
Yes, we told you we're like going
I don't know, you have to collect them and take them.
It's C-point.
Yes, Tipo is the one with the guy next, the red or Scotch roll.
I'm not with them,
Yeah, if I
We are fine.
Mine is here. Mine is in an hour.
Which of us must have?
Okay, you guys need to go to court date. Sorry. Joburg is coming.
Are they gonna bring us again? Say you guys are here. Go back. Same judges. Same judges, and they're gonna chase us away to say we saw you.
May I just ask, is it the same judges? Because the same judges can't see us.
Now, odds are we'll have that same issue that side. So.
But it's fine, they send us back. But if it's the same
But
judges.
then the proceedings are not going to get off.
Yeah, we're not gonna stand. Because this is fine.
No, this is
Have the same speaking out, yes.
I'll have to call you.
Michelle.
We have the same judges, miss. I'm not really. Oh, they're gonna change.
No, my God, is almost with a money. It's like, you gotta go with
We face the other two facing the same thing. If this country continues, we just hope for this.
But we can't decide that, that's the problem. It's not up to us to decide.
Misha, where are we supposed to go? Court C.
The
They
judges.
said the judges are not supposed
And I was told to come and move you because there was one judge here who was saying we've already seen this one team, so she was complaining.
But I think the arrangement was that the judges
The
stay,
judges
so
don't
the
move.
teams were supposed to exchange. So now they exchange, the judges make it worse now. Yes, they have to discuss.
I think you stay with those papers because you're still going to be adjudicating.
We've already filled
You've
our
already
names.
filled in the students. Okay, it's fine.
So you're gonna start the same exercise.
You guys are better. The other team, I'm sure
Okay, but
Ngadile's
can
team
we
is
get-
almost
can we
done.
get clean
The
ones?
one who's judging right now. Huh?
Can you get the clean ones? So it means you have to make 18 and then plus 12. Because 30 times is
Wait, had you already scored?
No, but we wrote the names of this.
Oh my god. Because I don't know if we're gonna get copies.
So we need 18.
18 Annex C and then 12 B. I mean, not 12, 6. I'm going to 16.
Dimakat, are we able to get copies?
Even mine. Hey, you gotta get 1 hour, then we come back.
No.
Let me keep mine for now.